Hello, everyone. My name is Orlando, and I'm very pleased to welcome you to the second installment of our TIAC Spotlight series organized by the TIAC 45 in the lead up to the Uzbek Arbitration Week. We frequently organize seminars and other training courses. I encourage you all to check our website and join as members. I would like to thank our speakers for making themselves available, and of course, Charles Tay for accepting to co-moderate this panel with me. Charles, please continue.
All right, thanks very much, Orlando. It's a great pleasure to be here. And I shall start by giving a brief introduction of our court and board members in attendance. There are 3 representatives from the TIAC Court of Arbitration over here and 2 representatives from the TIAC Supervisory Board. Starting with the court members, Elijah Putilin is the founder and principal of Putilin Dispute Management in Russia. And he has vast experience and has handled hundreds of cases in the Russian Federation and internationally throughout the course of his career. And in addition, he's also an adjunct professor in international dispute settlement at various universities in Central and Southeast Asia. Next, we have Olena Peripalinska. I hope I've pronounced that right. And she is a partner and head of arbitration at Integrities in Ukraine. She's also the president of the Ukrainian Arbitration Association. And over the course of her 18-year arbitration career, she has been counsel in more than 90 arbitrations and arbitrator in more than 60 cases. Third up, we have Dirk de Mulemister, and he is the founder and partner of DMDB Law in Belgium. And he has over 25 years of experience in arbitration as a counsel, as an advocate, and as an expert. There's so much more that I can say about these 3 people, but because time is short, I will have to move to introduce the 2 representatives from the board. As for the board members, we have Arif Ali, and he is the co-chair of the International Arbitration Group of DECAT in Washington, D.C., and he has over 30 years of experience in international in investor state, international commercial arbitration, and in private and public international law. He has handled cases involving the laws of more than 50 jurisdictions, and he had obtained the Order of Bahrain for his role in Bahrain's representation at the ICJ. And we also have Joe Tirado, and he's a partner at Garrigues in London, and he has over 25 years of experience in arbitration and dispute resolution, and he has been recognized as a first-class lawyer and is a prolific author of many publications. Like I said again, time is short, and I do not want to spend too much time on introductions. There's so much more that can be said about all of these 5 individuals, but we would like to get straight on into the meat of this session because that's what everybody is here for. And so I will let the speakers through their presentations introduce themselves more through the content of what they share. Before we proceed with our session, we would like to inform all participants that you can type comments and questions in the chat box at any time, and we would ask these questions to the panelists at the end of the session or at the right moments of time. And at the end of the session, we would reserve a few minutes for live Q&A. We would also like to inform the audience that this webinar is being recorded, and in the course of the following weeks, it would be made available at our website. And so I would now pass back to Orlando, who shall kick off this session.
Thank you very much, Charles. And I would like to start by asking a question to Arif. Arif, as a board member, could you please introduce the other members of the board and explain the main functions of the board?
Yes, of course, Orlando. And thank you to TIAC 45 and to Diana and the others for inviting me to join this very important session for a center, I think, that is truly innovating, and a center that is, I think, showing a great deal of leadership throughout Central Asia and indeed more globally. So I think let's start out by just mentioning who the other members are of the board, because that'll give you some indication of the high degree of respect that arbitration practitioners around the world have for what is happening at TIAC, and for the prospects that we see for growth of arbitration in Central Asia. So the other board members are Carolyn Lam, who's a partner at White & Case and known to many. There's Dr. Hussam Talhouni, who's a former director of the Dubai International Arbitration Center and current advisor to the UAE Minister of Finance. We have Professor Wei Sun, who's a partner at Zhonglun Law Firm in Beijing. Of course, my friend of many years and colleague, Joe Tirado, who is co-head of international arbitration at ADR at Garrigues. As was mentioned, we have Michael Davison from Hogan Lovells, Professor Khaur Qureshi, who is a Queen Counsel at Searle Court in London, and the head of chambers at McNair Chambers in Doha. We also have Professor Attila Tanzi, who's on the board. He's a member of the Permanent Court of Arbitration, chair of international law at the University of Bologna, and an associate member of 3VB Chambers in London, and yours truly, myself. So as you can see, it's a very, I think, I'd like to say, experienced and thoughtful and committed board. The board is intended to ensure the independence of TIAC. Its functions are to contribute to the vision of the center as it evolves, to approve initiatives, to approve and to suggest initiatives to help with establishing the legitimacy of the TIAC arbitral system. So, we have been engaged in, I think most importantly of late, in the approval of the TIAC arbitration rules. There are a number of innovations in those rules, which I'm sure we'll come to. We've also been assisting with Diana with input on negotiating a memorandum of cooperation with the Uzbek Supreme Court, with development of the mediation rules, development of the technology dispute resolution rules. So there's quite a bit that the board does. I think I should mention that the board is completely independent of the TIAC court. The board does not get involved in any case administration matters. Our role is really more in terms of assisting with the governance of the institution as opposed to case administration. I hope, Orlando, that answers your questions regarding the board and its functions. If there's anything else you'd like me to follow up on, I'd be happy to do so.
Thank you so much, Arif. At this point, I think it has been very helpful. And now I would like to move to discuss some issues related to court members. So perhaps, Olena, can you please introduce the court members and its features and functions? And perhaps Elijah and Derek may also elaborate more on the comments made by Olena. Thank you.
Yeah, thank you, with pleasure. So for now, we have 5 court members, and in addition to those 3 present today, we also have Stanimir Alexandrov and Aybek Akhmedov, and Aybek is the only Uzbek lawyer in the composition of the court because according to the rules, not more than 20% of the court members may have Uzbek nationality in order to ensure the truly international composition of the court. And as you could see, we have court members from various jurisdictions with quite diverse background. And again, this is to ensure diversity within the court and high quality of the court work. With regard to the court itself, so this is the body within the structure of the TIAC, which is in charge for administration of the cases. It basically deals with all the issues related to appointment, replacement, or confirming of arbitrators. Then it deals with the costs and fixing the arbitration cost. It deals with overseeing of the arbitral proceedings, and last but not least, the scrutiny of arbitral awards. It's also important that the court is not only autonomous and international body, but it also independent in all senses. So it does not depend on any other bodies of the center. And in addition, within, again, according to the internal rules, the court members may not act as arbitrators under the TIAC rules. And this is again to ensure their impartiality when they perform their functions as court members. So in brief, this is probably all. I'm sure that we could, so first my colleagues could add something, and then we could talk more about each of the functions of the court. Thank you.
Thank you so much, Elena. I would like to know if Elijah and Dirk would like to elaborate a little bit more, or if there is nothing else, we can pass to the next question.
Thank you, Orlando. Just maybe 2 cents on the composition of the courts and why it matters. So a phrase often attributable to one Greek philosopher: in disputes, the truth is born, right? So the court offers the secretariat a plurality of opinions. And this in turn ensures the best service possible delivered to the parties.
Great. Thank you very much, Elijah. And Dirk, is there something else you would like to add?
Oh, not much, but maybe point out and congratulate the member of the Secretariat. The court could not be able to work in an efficient way as we do without the Secretariat supporting us and preparing the files and in order to have, as I said, efficient meetings. So I want to thank them and congratulate them for that.
Thank you very much, and also to the Secretariat. And Charles, please, you may take the lead now.
Yeah, right. Thanks very much to everyone for the introductions of the board and the court. Let's now talk about TIAC as an institution. Now, as we know, TIAC is a fairly new arbitration institution which was formally launched in April of 2019. And in the course of the formation of an arbitral institution, there are many things that need to be done, that need to be prepared. For example, one of the key one key such matter would be the formation of arbitration rules. And so I would like to ask a question to the board members. Would it be possible if you could tell us a little about how the TIAC arbitration rules were formed? For instance, were there certain practices that were taken into account? And who were the participants of the working group in the development of these rules?
Joe, you want to kick that off, or I'm happy to do so.
Arif, I was expecting you to kick off, but yeah, why don't you start and I'll chip in?
All right, happy to do so. So, look, as with any rules development, there are 2 particular facets that you have to look at. You've got to look at it from the standpoint of, I'd say, comparative rules development, comparative law, and then the specific situations of the institution. And as with any institution, I think you have to borrow the best practices from other institutions, given that a new institution by definition doesn't have a significant caseload in terms of informing the rules development. So of course we looked at the rules of many different institutions, and you'll see that the TIAC rules do reflect the best practices of leading sister institutions around the world. But there are, in addition, a number of innovations that are reflected in the rules, and I think that these are important to mention because they are sourced from the decree that established TIAC, but they're also intended to ensure a couple of different things. First of all, a very significant emphasis on independence and impartiality, and secondly, on access to justice. And I think that from the standpoint of access to justice, one of the interesting aspects is that there are no administrative fees that are applied, but what I'll do is just run through some of the innovations, and we'll talk a little bit more about the fee innovations in a second. So pursuant to the rules in the decree that established TIAC, parties to a dispute are allowed to engage foreign arbitrators to resolve their disputes. Arbitrating parties can resolve their disputes in accordance with the substantive laws of jurisdictions other than Uzbekistan. There's a significant set of instructions that apply to the granting of interim relief and the interactions with local courts. As I said, there are no administrative fees that are applied. Perhaps there's some other things that Joe will refer to in terms of the rules development. The rules went through a number of different iterations. They were discussed amongst the board members. There were various drafts that were reviewed and then were ultimately adopted by the board based on a comment period that allowed, provided for input, and thereby helped to legitimize the rules as reflecting best practices in international arbitration.
Thanks, Arif. If I may, I will just chip in. First of all, let me also thank you for the introduction and the kind invitation to join you and participate in today's event. I hope technology works. I tried tuning in a few days ago, and believe it or not, my router overheated because of the extreme hot weather we're having in the UK at the moment. So that's not often that people can claim that, but so far so good, and I've got the fan on it. So I hope we don't have any technological problems. Well, yes, just to reiterate really and echo what Arif has said, in terms of who was engaged, it was the entire board. We were all involved. It's very hands-on. It's a relatively, well, I'm not sure if it's relatively small in terms, but it was, everybody was involved. There were several iterations and a genuine attempt, I think, to get a revision of what the main arbitration rules are, what practice is, to try and incorporate all of that and get as close as one can get to claiming we have essentially state-of-the-art arbitration rules. Having said that, it's recognizing that these are organic processes, and you're always in a process of evolution. And there's already proposals for draft mediation rules, for example, and draft technology rules to take it to another level. So I think this is not a static process. It's forever under a state of evolution and review. But I think that is the clear message that one wants to send. It's one of the key important parts. There are many other planks that I think we'll touch on later, that in terms of building an international institution, a jurisdiction that is recognized as arbitration friendly, but having clearly workable, recognized, credible arbitration rules is got to be pretty much there at the starting point. So I commend people to read it. If people have think there's any omissions, we're open. No pride in the authorship. It's a collaborative attempt, and we're always just trying to improve. So I think without further ado, and conscious of time, I will.
Yeah. Thanks so much, Arif and Joe, for your introduction to the rules. I noted that Joe, you mentioned that there are the mediation rules and the tech rules, and these are some of amongst the initiatives that TIAC has been undertaking. Could you tell us more about these initiatives, and if so, and as well as about any other initiatives that TIAC is undertaking?
Well, I'll do my best to be brief about it. I mean, one obviously recognizes this is a young institution. There's a lot of work to do in one go. There is a recognition, and I think indeed Arif had made reference to the decree establishing the institution, a broader view to dispute resolution beyond international arbitration, and that needs to be a cost-effective way of resolving disputes. So a greater emphasis on mediation. One is seeing globally being promoted by such august institutions such as ICSID in Washington for mediation, particularly in investor-state disputes. This is something that candidly many institutions have not taken on board or have kind of paid lip service, but I think there is a growing recognition that this is a fundamental service that should be regarded for any international dispute resolution center. So Diana will be in a better place to say quite where we are in the process for the draft mediations. Rules have been circulated. I don't believe they've been approved as yet for mediation. As like with the draft technologies rules, which I think it's trying to be crumbs. If anything, we've learned from the last 18 months, 2 years with the pandemic, the importance of technology, and actually a recognition of that this is a future growth area, artificial intelligence, blockchain, disputes are likely to rise, and those rules are very much kind of aimed at addressing that and capturing that kind of market for disputes. So they're still, to summarize, work in progress, but very close, I think, to actually being implemented. And indeed, as I say, just to reiterate, it's not limiting ourselves. I'm sure there will be other areas, perhaps in energy-related disputes, that we will investigate in due course. But I think it gives a sense already that this is a very open-minded institution with a true international body behind it, and the institution is reaping the benefits of that truly global vision.
So
yeah, Charles, let me also add very quickly, if I may, is that I think that aside from the technical development of rules and the process of legitimization that we are engaged in as part of the rules development, there's also a very important function in the initiatives to develop an arbitral culture and to promote an arbitral culture in Uzbekistan to complement the legislative developments that have been taking place since 2018. Or even going as far back as 2016. Look, Uzbek Arbitration Week, for one, then the TIAC 45 Young Practitioners Group as well, then the development of different MOUs with arbitral institutions. And I think extremely importantly is the constancy of interactions with the Uzbek judiciary, because obviously we need the support of the Uzbek judiciary to help promote not only a legal framework, but to disseminate arbitration and international arbitration as a method of dispute resolution that gets into the fabric of commercial society in Uzbekistan and with those who are contracting and doing business abroad. So I think that arbitral culture element is also a very significant part of what we are trying to promote.
Arbitral culture, that's very interesting. Like, I understand that in Uzbekistan, for hundreds of years perhaps, and not just in Uzbekistan, but also in the wider region, there has been perhaps a culture of alternative dispute resolution, perhaps in a form that's similar to arbitration, whereby certain elders may participate in the resolution of disputes between different people. And it's very admirable that as a new institution we work together to promote the culture of arbitration as a neutral means of dispute resolution between businesses, between individuals within Uzbekistan, and between Uzbek parties and foreign parties. Now, since TIAC's launch in April 2019, it has been operating now for slightly more than 2 years, it seems. So during this time, I understand that there have been more than 20 requests for arbitration that TIAC has received. As you are all persons who have witnessed this development, Orlando and I would like to invite you to ask if you could perhaps share some of your thoughts about these and your experiences so far. In the course of managing arbitrations, perhaps we could start off with talking about the appointment of arbitrators. The court has a role in this, and we would like to invite the court members to perhaps share a little about how do you manage this.
Well, to break the ice, I would say we managed it quite efficiently. And
well, I was looking for the unmute button. It's true that one of the main features or tasks of the court as an independent body, I think, and the most important job I think we have is to safeguard the integrity of the institution when we take decisions in accordance with the arbitration rules. When it comes to appointments, as everybody probably knows, TIAC has a panel of arbitrators which is published on the website of TIAC. The panel consists of some 40 potential arbitrators who can be appointed, and obviously there's also a reserve list of some 15 arbitrators. What basically happens, because there was a question in the chat just earlier from John, who said, what does the court do that the Secretariat doesn't do, and vice versa? Obviously, the Secretariat is the body which is in contact with the parties and with the arbitrators, which is something that the court doesn't do. Basically, the Secretariat will submit a number of questions based on the file to the court, and we will deliberate and discuss during our regular sessions by video. We will discuss these issues and see if we can come to some kind of consensus or a majority decision. In essence, you could say that the members of the Secretariat are the pilots flying the plane, and we are sort of air traffic control, trying to guide it into the right direction. But let's go back to the appointment of arbitrators, because the one question we all get, I'm sure, as arbitration practitioners, both from students and youngsters and young people and established people, is how do you get appointed? Well, again, in this case, there's a list of arbitrators. There's a panel which is published on the website of TIAC. And what will happen is that the Secretariat, based on the case at hand, will look at the CVs of the members of that particular panel, look at qualifications, look at language, etc., all the classic ones, and will then submit to the court a list of 3 names from which we can, or we normally will choose and debate one by one, and we'll put them in a certain order. Back in the days, I remember we requested the Secretariat to do a first, before they would submit any names, they would first have a short contact with that potential arbitrator in order to make sure that this individual was available. And so it goes quite smooth. And so again, it's based on the proposal of the Secretariat that the court comes to a decision. One of the elements, and I'll be quite brief, Charles, but yet it's important to give some figures and statistics if that is of the interest of the audience. When it comes to diversity, which is at the forefront, I think, of every single arbitration practitioner out there, that is something that we take into account very, very seriously. When it comes to gender, we are now -1 when it comes to women and 1+ when it comes to men, but I'm sure at one of the next court session we will balance that one out, so we take that into account. Most arbitrators were in fact appointed from the main list of arbitrators. Only once we had to go back to the reserve list panel in order to appoint an arbitrator. It is very international. We have Russians, Lithuanian, somebody from Egypt. In fact, up until now, I'm afraid only one Uzbek national was appointed as an arbitrator, and in fact, somebody who is sitting or practicing arbitration out of Switzerland. So that is my 2 cents on appointments, and I'm sure my colleagues would like to add.
Yeah, I could jump in to say that, of course, in each case, there are a number of factors to consider when selecting arbitrator to be appointed by the court. And quite often we appoint the sole arbitrator, and probably that is why it makes the requirements and challenges to our task even higher. And in addition to what Dirk has described, we've also taken into account the complexity of the case, nationality of the parties. Again, if this is a sole arbitrator, this is important to consider. And of course, issues like conflict of interest and again, we have not dealt with it, but I'm sure that when we have a candidate with some orange list circumstances, we would be probably hesitant to appoint such person as a sole arbitrator if we have some crystal clear candidates in order to avoid any problems in future. But in any case, this is a collegial decision, and in each particular case, we take different factors into account, all that described, because sometimes the language issue could be important or some other aspects could be important, and we all discuss this and take decision as any decision of the court, so by majority. And this is also important. And technically, as a court, we are not limited with the panels and with the list. So the list is more for the secretariat to assist the court. And this works pretty efficient because the court possess all of the secretariat possess all necessary information to provide the court members quite quickly and to ensure prompt selection of and appointment of arbitrators. And of course, availability is also an issue. But this is a separate story, I would say.
Now, on this issue about availability, sometimes you could imagine that there may be certain cases where fast availability is required. For example, where an emergency arbitration, for instance, is sought by a party. I wonder if there's anything that you could perhaps comment about this.
So again, first, it is important to note that TIAC rules have emergency arbitration provisions, and not every institution in the region could say so. And even more, we have already applied them on a couple of occasions. So even within those 2 years of activity of this young institution, there were several requests on appointment of emergency arbitrators. And I would probably explain how it worked. Yeah, because we have some experience. So according to the rules, once the application for appointment of emergency arbitrator is filed by a party, the court has to take the decision with regard to this application. And once the decision is taken, the court has only 3 days to appoint emergency arbitrator. So again, we have our 5 court members, and we need at least 3 votes to take any decision. And we've managed to do this in these 2 cases. Then again, it was very important, and this was one of the crucial issues for us to be sure that the candidates to be appointed as emergency arbitrators are really available for the next several weeks to deal with this emergency arbitration procedure, because once the file is transferred to the arbitrator, together with the court and the secretariat, they all have only 15 days to render the emergency arbitration award. the decision. And this period includes the proceedings, the drafting exercise, the scrutiny exercise, and sending out the word to the parties. So every participants of all these procedures should make him or her self available to comply with the deadlines. And again, we have successfully we all, I would say, successfully complied with that mission, and two decisions of two emergency arbitrators were rendered in two different cases. And we had very hot debate with regard to the appointment of those arbitrators. And we actually, if I'm not mistaken, we have declined all the three candidates initially offered by the Secretariat and pick up the candidates from another list at that situation, taking into account peculiarities of the case. So it was really hot, but in any case, fast and I hope efficient. Thank you.
Well, that's a very, very, very fascinating introduction to the inner workings of the court in terms of how emergency arbitrators are appointed and how such cases are managed. Perhaps now we can I would like to invite Orlando to proceed with the next question to the court members.
Yes, thank you, Charles. I really enjoy very much the description of the powers of the court as an airport traffic control tower, and I think it's a very good description of some of the functions of the court. So at this point, I would like to ask Elijah if you see that there is any overlap between the functions of the court and arbitral tribunal's scope of decision making. And perhaps I would like to point some examples on the roles that are related to jurisdictional challenges, joinder, and consolidation, or other matters such as time limits that you may want to comment on. Elijah, please.
Thank you, Orlando. First of all, I wouldn't say there is an overlap. According to the rules, the tribunal is the ultimate decision maker. But in a situation where, or to be more precise, when there is no arbitral tribunal, this is when the court steps in. And as you mentioned, one example, consolidation and joinder. So a request to join the party or request to consolidate the proceedings may arrive at the Secretariat's desk prior to the formation of the arbitral tribunal. So it is for the court to decide upon this request. As far as the jurisdictional challenges are concerned, if one carefully read the rules, it says prima facie evidence of arbitration agreement. So it's the very, very basic check or verification of the jurisdiction, just to avoid, opening the floodgates for unsolicited submissions from anyone saying, well, we're going to arbitrate under the TIAC rules where there is no arbitration agreement whatsoever. And of course, TIAC rules, much like other arbitration rules, allow the tribunal to decide upon its own jurisdiction. So it's still with the tribunal. As far as the last point you mentioned is concerned, namely the extension of time periods to render the award, well, the court's duty and the TIAC's duty is to ensure the proceedings are run smoothly and efficiently. And sometimes the arbitral tribunal may not be willing to or may not be able to deliver the award on time. So this is sort of a carrot and a stick approach. So the tribunal must deliver, but if the tribunal cannot, well, the court will have a look at the reasons why, and then either offer the extension of time or not. So this is the policing power of the court to ensure the proceedings are run in accordance with the rules and to the best of the parties' interests.
Elijah, thank you very much for those clarifications and putting on that there are different functions or roles between what the court is intended to do on the tribunals. And now at this point, having discussed some issues of the procedure, I would like to ask Olena on issues related to the scrutiny. how the court scrutinizes the award, and perhaps if you can point what benefits you see on the scrutiny, because there are certain institutions that do not have scrutiny. So if you can tell us a little bit, that would be very helpful. Olena, please.
Yeah, sure. So far, we've done scrutiny on several finals award and of emergency arbitrator award, but the procedure was pretty the same if we do not take into account the deadlines, which were different. So the Secretariat circulates a draft award to all court members, and all court members within the pre-agreed or established deadline have to review and make some comments and share those comments with fellow court members. And sometimes this generates some follow-up discussion on some issues, because we look at the comments of each other and may agree or disagree or develop some ideas. Then the Secretariat collects all those comments and send the award back to the tribunal. The tribunal works with the comments, sends the draft award back to the Secretariat. Secretariat again send it to the court members, and then we finally prove it if we are satisfied with implementation of the comments previously raised by the court. The Secretariat is also involved in the process of scrutiny, because there are many issues the court may not be aware of, because the court is not involved in the day-to-day communication with the parties and arbitrators, so the court does not have all the details of each case, and that is why the Secretariat could double check some issues described in the award, identify or spot some typos, etc., etc. And the court members look at the award first of all with from the perspective of its enforceability, but again, based on the background of each court member, the comments may be quite different, and in the end, we discuss if we have issues or some doubts with regard to some comments. And again, this is so a developing practice, because the number of cases is rising, and with each new case we have more and more practice, and even in our internal rules of scrutiny.
Olena, thank you very much. It's very helpful. And here Rocio Digong is asking us, how or is the scrutiny different from scrutiny from ICC arbitral awards? I don't know if you have any other comments or views on that.
So I'm also ICC court member, so I definitely could compare.
Great.
Yeah, but here I should say that the institutional rules are a bit different, and the ICC court and ICC secretariat are definitely different from the TIAC court and secretariat, even in terms of the number of people involved in the proceedings, because in ICC court we have almost 200 court members, and not each member is involved in scrutiny of each award, while in TIAC we are all involved in this exercise as court members, and we all receive the draft award for scrutiny. Again, with regard to some standards and internal procedures the institution could have, and again, different approaches, and ICC has almost like 100 years of experience and some established practice, while TIAC is developing its own standards and rules, and so there is a difference because of all these reasons, but I think so far, what we have scrutinized as a court, we have done it in quite like thorough and detailed level, and I hope this helped to improve the quality of the awards and to comply our mission as the court members.
Thank you, Elena. And I have just two additional thoughts. Do you have any experiences at reviewing defaulting parties, awards with defaulting parties? Are there any particular issues you take into account in order to secure their enforceability? And also, I have never seen a case or an arbitration clause pointing the tribunal to decide ex aequo bono. So I would like to know if the court has experimented some issues related to defaulting parties and the application of an ex aequo bono decision.
I will start, and I hope my colleagues will join the discussion. So we had, of course, we had both. So with default party, I think it's not a rare situation. So we definitely had them. With aequo bono is a more so it happens not so often, but we had a case with that already, and it posed some interesting issues, including in scrutiny proceedings. With regard to the defaulting party, I think it's a problem of the tribunal more than the problem of the court. So what the court could do is just look if the notification is properly described in the draft award, and to ensure that this issue would not arise during the enforcement of the award in some jurisdiction. But it's the function of the tribunal to ensure proper notification within the proceeding itself. With regard to ex aequo bono, so again, if the parties have expressly authorized the tribunal to decide the case based on that principle, so technically it's possible. The issue is so how the court should approach the findings of the arbitrators and his or her reasoning when the arbitrator tribunal is vested with such powers, because from enforcement perspective, this could pose quite interesting questions, because whether the tribunal should rely on some legal norms or not, or if the tribunal's findings are not in line with some legal provisions, whether this should be elaborated in details with reference to ex aequo bono powers or not. So there are quite many interesting issues, and this poses so this sparkled discussion within the court, and I pass the floor to my colleagues to add their view on this.
Dirk, Elijah, perhaps if you have in a nutshell, some views on ex aequo bono.
Sure.
So, I'll leave that one to Elijah.
Yeah, I don't really have much to add to what Alena said, but as far as decision as to what is right and what is good is concerned, yes, it's sparked a lot of discussion among the court members. And the reason is we all come from different backgrounds. And while the court does not intervene in the thought process of the tribunal, we still need to see the reasoning behind the award. So we have different, Alena and I had different approaches to what the reasoning should look like in this particular case, but ultimately we agreed. We agreed. I hope so.
Thank you very much for sharing these intriguing thoughts on ex aequo bono. And I would like to pass the lead to Charles, if there are no, Charles, please.
Yeah, no, it was very interesting listening to all of this, you know, like the information that's been shared about appointments, about powers of the court, about the scrutiny process. And I call on that that Olena mentioned a very interesting fact earlier on about the composition of the court of TIAC. It's not as large as the court of the ICC, of which Olena is also a member. And in terms of what we've heard about the level of involvement of the court members in all of these processes, appointment, like powers and scrutiny. If I may, I would like to ask perhaps a slightly daring question, and that is it possible if I could perhaps get some views, opinions about, I'm personally quite curious, how are TIAC court members selected and appointed? Would anyone be able to answer this?
Well, I will endeavour to chip in. TIAC court members we're talking about.
Yes, TIAC court members.
Yeah, well, I think we were certainly one of the roles of the supervisory board was to approve, not all of them. I think we've approved about half of them. But that's one of our functions and contributions, was to identifying candidates and approving candidates that were put towards us that we thought would make good court members who could deal with the myriad of issues that has been very usefully outlined for us.
Well, that's very fascinating. So it's a little bit of an insight into how in the workings of an institution, the board members.
I think Charles, what I would emphasize of that, if it's again not apparent from what we're talking about, is the collaborative approach to this. This is not somebody's best mates that is being edged into. We are all consulted, and I think as a result, therefore, have to justify why somebody's either being proposed. And so I think it is with that endeavor to ensure that we get the best people we can possibly find who are prepared to take on the role, serious about the role, who are focused in developing the objective of the center. So it's, I think that's worth pointing out. It's not a diktat from one individual, be it within TIAC or outside TIAC. It is a collaborative approach.
Before we move on, I would be curious, would there be any views from court members in relation to this, perhaps Doug or Elijah?
In terms of how I was appointed? Just to clarify, Charles.
We can't get it right all of the time. No, I'm joking.
Yeah, I think it's very important when appointing a court member of a young institution is to ensure that the court members are willing to invest. And all court members to date have invested much effort and much time in developing the internal practices, in ensuring the rules are applied as they were designed to be applied. So yeah, that's my 2 cents on that issue.
Well, thanks very much for this little detour. I hope that worked. That gave some insights to the audience. And now I think it would be a good time for us, since we have, like we said at the start, court members and board members here at this meeting, at this webinar. We would like to now shift our focus to certain questions to the supervisory board members over here. And to start off, can I ask to the board members, what are some of your views on the best policies and strategies for running an arbitration institution on a large, big picture macro level? Could I invite Joe, please?
Shall I, Arif, if you're happy for me to kick off? I think what I would start off by saying, at the risk of stating the obvious, it's important to establish, before strategy and policy even, you want to establish what your goal or objective is. And then obviously how you wish to achieve that. Charles, you referenced the tradition of the white beard, Aksagal, I think, if I've not completely murdered that pronunciation, which I had until I shaved mine off yesterday, which is encouraging. There is obviously a tradition of dispute resolution within Uzbekistan, but to be candid, it wasn't very arbitration friendly, or indeed from an international perspective. That certainly changed in the presidential decree of 2018, which effectively gave TIAC the mandate to set up and implement state-of-the-art dispute resolution services for the business community in Uzbekistan, the CIS region, and further abroad. So in TIAC's foundation, specific emphasis is placed on international commercial and investor-state arbitrations, including disputes at the frontiers of law and technology that I've already referred to, such as artificial intelligence, blockchain disputes, and other disruptive technologies. Interestingly, the decree not only provided a waiver that are now licensing, waiver of licensing requirements for foreign counsel not to act just in arbitral proceedings in Uzbekistan. So that changed the previous. It went a step further, which I think is interesting because there are relatively few jurisdictions. It also, in arbitration-related court proceedings in Uzbek courts, allows foreign counsel to make representation. So I think that's quite an important distinction. So I think it's very clear from the very beginning and the ethos behind the presidential decree that TIAC's outlook is very broad in terms of the dispute it's dealing with, truly international, so beyond the region even, and certainly very innovative. But in terms of kind of then looking towards, I suppose, the strategy and implementation, I mean, just a couple of things that spring, you can spend hours on each one of these, but just to throw out points that I've observed, and I stress they're personal ones, so if people disagree with them, I'm sorry, but I hope they will at least stimulate some debate. But it all starts with people. Again, at the risk of stating the obvious, we overlook that. And it starts right from the very top, when you've got key personnel is vital. So when you have people at the top with Diana's director of the center, but it's her support colleagues, the secretariat, clearly who gets on the composition of the supervisory board and the court, and of course the panel of arbitrators. At the end of the day, it's all about people, and you need to have people that you could trust, who can provide the necessary credibility. It's also, I'd say, you need buy-in. I mean, it's a multifaceted approach. We've already touched on some of this already. Government is truly very important, in particular, having legislation that's workable, that's attractive. We know that there has been approved, but not yet enforced, a new law on international commercial arbitration, which I think in under 4 weeks' time will be come in force in Kazakhstan on the 16th of August, 2001. So this will align the law with UNCITRAL model law in international arbitration. Again, you know, an important external signal that this is modern and a reliable legal framework. But other issues such as funding, I know TIAC doesn't actually rely on government funding, but I think there is an important role there to perhaps help with the development of institutions such as TIAC, but practical things such as travel visas, making it as simple and as easy to travel in and out of the country as possible. Other important ones, of course, judiciary. RF has already touched on that, but in particular, I think it is important that you get to buy in. My understanding of recent court decisions is that they are showing themselves to be arbitration friendly, both in enforcing arbitration awards in Uzbekistan, but the buy-in of the judiciary is fundamental. Some practical things, we've already touched on the arbitration rules, but I mean, that's important to make sure that you have important state-of-the-art arbitration rules that are flexible, that are evolving all of the time. Modern facilities, both in person, if you remember those, some of us do, and we're now beginning to see some of those again, but of course increasingly remote. And I think that will be the legacy of the pandemic. There will be the hybrid culture going forward, but having effective modern facilities is important, effective case management, all of this, you know, any one of this can fall down, but having a secretariat that supports counsel, arbitrators, the work of the management of TIAC is really super important. I can't stress that enough. And it varies enormously. We've all had bad and good experience at different institutions of having great counsel administering a case, but that cannot be underestimated. The sheer reality of it is we're all looking, there are so many, there are hundreds, if not thousands of international arbitration institutions. Many are international, claim to be international as well. So differentiating is a key thing. The exemption of VAT charges for TIAC arbitration services is a plus, of course. Exemption of income tax for foreign arbitrators is always welcome. But importantly, TIAC has implemented a zero admin fee policy for its administration of arbitration. I think that is unique in the world. So that's obviously putting your money where your mouth is in terms of attracting, and people need to be attracted, particularly when you're a new institution, but that is definitely worth flagging. And with this, Arif, I will hand over to you very briefly, but marketing's super important. This is a prelude to the Uzbek Arbitration Week. I just want to make a plug for that and encourage people to participate in that. That's coming up in September. I want to applaud you, Charles, Orlando, and Kirsten, but the work of TIAC 45, the young practitioners who are really the workhorses of spreading the word, which is what it's all about. And so for organizing important events like today. Also, I think the fact that the TIAC has established a number of international initiatives with joint collaboration agreements with various institutions, super important for spreading the word. Again, serious, credible institutions such as Hong Kong International Arbitration Center and the Vienna International Arbitration Center. And then with this, we've already touched it, looking to, again, differentiate yourself. We've talked about the competitive thing, but looking at additional services. With the technology rules, which we are on their way. Getting involved, I think, proactively in capacity building with Uzbek judges is important, the mediation rules, and just general educational events. I think all of those are important factors for promoting and raising the profile of the institution. Forgive me, a bit of a bit of a whirlwind of points, but Arif, I'm sure we'll have 100 more to add as well.
No, thanks. No, thank you, Joe. I mean, I'll try and boil down at the macro level what I think is critical for an institution that is that's new and establishing itself as a leader in the space. I think you need to be international, which is something that TIAC is. Needs to be inclusive. If you look at the composition of the board and of the court, you'll see the diversity of individuals in terms of systems of law and in terms of perspective that Elijah referred to. I think you need to have a secretariat and participants who are informed and who are informative. So in terms of being informed, you have to have people who are, I think, experts in international arbitration and best practices on a comparative law perspective, but sensitive to particular regional specificities or particularities. And you need to be informative in the sense of transparency and disseminating information as to what it is that the institution is doing, and ultimately independence. So I put that all down to the 5 I's. And I think that all of these things have been reflected in TIAC's policy development, rules development, initiatives, and the specific items that Joe mentioned. But I put it down to the 5 I's.
Well, thank you very much, Joe and Arif, for these introduction to the thoughts and directions of TIAC. Another question now for the both of you again, Arif and Joe. You are the first members of the board of TIAC. You are the members of the first board of TIAC. And this was a pioneering effort because TIAC is a new arbitration institution. At least a few years ago it was, and now it's gathering momentum. It's growing and it's expanding fast. Before this process started, could we be interested? Why did you decide to join this initiative and the board of TIAC?
Maybe I'll start there, Joe. You know, I was born a Pakistani, so another Istan. So for me, it was a matter of great pride to be part of an arbitration institution that was being set up with aspirations of excellence, which I believe have been and will continue to be achieved. So I think as someone who comes from an Asian country, I wanted to participate for that reason, of course, to be part of something that's a startup, to be able to try and contribute one's the knowledge or wisdom that one has developed over the years of practicing in different jurisdictions to say, well, there comes a time when you're not necessarily just focused on what you can take from the system and from the profession, but what you can give back. And I think when Diana reached out to me, it gave me, I was excited to be able to participate in something that was innovative and that I could contribute to as an Asian and to a growing economy in a Muslim country.
Yeah, well, in my case, certainly I like flattery like everybody else, I suppose. And so I was very pleasantly surprised to receive the message from Diana, whether I would consider. I've done quite a lot of work in the CIS region, not in Uzbekistan specifically. But I think having the opportunity to participate, as Arif was saying, in something innovative and to hopefully make a difference. I mean, we all have our bugbears and experiences of elsewhere where you can hopefully influence things in a way to address those issues is certainly one of the value addeds, and I think that we all are obliged to do, and frankly more of us should be doing more of that kind of work, I think, is in our stage of the career. But of course, having the opportunity to work with old friends and colleagues that like Arif, who I admire and respect as practitioners and frankly like being with, is always makes that choice even easier. And ultimately, anybody that knows Diana, she's a hard lady to say no to anyway, so it wasn't, there was no point resisting.
Yeah, well said.
Thanks very much for your thoughts. This is very, very fascinating. Orlando, over to you.
Thank you, Charles. And I would like to ask both Joe and Arif if you have any thoughts about Uzbekistan as a jurisdiction for arbitration. And I think my question is timely, given that Uzbekistan has enacted a new law on international commercial arbitration, which will enter into force on 16 August 2021. So what kinds of changes do you think that the public can expect to see following the entry into force of this new law?
That's Orlando. That's a big question. I mean, two big questions that are embedded in what you just said. I mean, I think is Uzbekistan what are my thoughts on Uzbekistan as a jurisdiction for arbitration? I mean, what I can say is that we've referred to the history of let's say informal dispute resolution and let's say elders and community arbitration or tribal dispute resolution. In Islamic law and Islamic tradition, the arbitration is something that is very well established. But what does that mean for a modern and modernizing country? I think that if you look at the initiatives that started in 2016 that Joe was referring to, there was already a focus on implementing formalized legislative infrastructure for the development of alternative dispute resolution. And we see then the trend continuing with the establishment of TIAC, with the adoption of the new arbitration law, all the things that we've been discussing. And we've also seen, as Joe was mentioning, that the courts in Uzbekistan have reflected an openness to arbitration. We're seeing that there are decisions, at least one decision that I'm aware of, that where the court was the enforcing court decided against a state-owned enterprise. So these are all positive indicators, and I think that we should be cautiously optimistic. But I would also emphasize the word caution. Let's not get too excited. There's a lot of work that has to be done. There's a lot that we have to constantly be wary. There are constantly changing political dynamics. There are constantly changing economic dynamics, and often from circumstances that none of us could have expected, such as the pandemic. So I think that we need to keep these efforts going. We need to keep emphasizing. We need to keep pushing. We need to keep pressing the courts. We need to make sure that the legislators understand why international arbitration and developing an arbitral culture is extremely important. I mean, there are positive signs, but there remains a lot to be done. So, what will the public, what can the public expect? I mean, I think that, other than those who are arbitration geeks, I don't think that overall the public is going to be suddenly bowled over by the fact that there is a new international arbitration law. I think it's going to take continuing efforts at educating why international arbitration is important, why this is something that will help with increasing business, what international arbitration means, that it's not just going to be arbitration in Uzbekistan, but it could be arbitration that the parties will engage in outside of Uzbekistan. What does that mean for them? I think that those are really at the grassroots level. There will need to be an effort at educating commercial society. And I think that there's leadership that can also be shown by companies like Uzbek Neftegas, as well as state-owned enterprises. I think it's going to be important for legislative developments to be considered, such as in the public-private partnership laws and the procurement laws that Uzbekistan is considering and evolving to insert arbitration as a mechanism of dispute resolution, whether it's taking place in Tashkent or elsewhere. So there are, those sorts of things that as you start to infiltrate the concept of international arbitration into society, then business people begin to see its benefits. But that will take quite a bit of doing.
Thank you very much for your reflection, Arif. And as I see, it's a component of a major series of components and aspects that need to play together in order to produce the intended effects. And I have just last one question also for you, Arif. Uzbekistan has a population of more than 34 million people and undertakes quite significant international trade. Based on last year's statistics, the top 5 trading partners of Uzbekistan are China, Russia, Kazakhstan, South Korea, and Turkey. There are traditionally over 50 Uzbek foreign BITs. Does the trading situation of Uzbekistan influence how the board decides to direct its efforts in promoting TIAC?
Yeah, no, I mean, certainly speaking for myself, no. I mean, I think that there is, we aren't particularly focused in saying that we are, let's just focus on those particular jurisdictions. I mean, we're looking at disseminating at this stage of the game, all of the things that we have just been discussing for the last hour or so as to why arbitration is growing, or why it is something that has now become part of the discussion of the legal framework of Uzbekistan. I mean, I think Uzbekistan as a transitional economy is looking for foreign investment from all over the world, and it's looking to increase its exports of precious minerals as well as cotton, both of which are in abundant supply in Uzbekistan. I think that you have a need for significant imports of commodities into Uzbekistan and to attract foreign investors who are going to engage in hydrocarbons extraction. So, I mean, ultimately, we have to recognize that Uzbekistan is as an economy that is growing. It's growing fast. It is an economy that's continuing to be in transition, and it needs to give foreign investors and commercial parties a sense that there is that international arbitration and the legitimacy of court decision making is something that they can count on. So, I think that's our goal at this stage. It's not necessarily focusing on very specific jurisdictions, although there are activities that take place that are focused on jurisdictions like Turkey and China, but I think increasingly with Saudi Arabia and countries that are part of the let's say the Islamic finance world, where capital is looking to come into countries like Uzbekistan, which is 98% Muslim.
Thank you. Yes, go ahead. Sorry.
I'm conscious of times. I just wanted to echo Arif's typical wise but cautious words. I think the new law is definitely a step in the right direction, but it's not a panacea. It's not going to complete the next day see a flood as much as we'd like to see that in international arbitration, but it's definitely something that goes in the right place. As with all these, one has to take the long-term view. There's always a real impatience to want to get on and do things as fast as possible. The institution, in my experience, has had far more success than other institutions in the relatively short time it has existed than any other. That is fantastic to be built on, but again, as Arif widely counseled us, I think cautiously, one builds on that. I just wanted to add and kind of build on what's the last words of Arif is that this is a fantastic opportunity for Uzbekistan as it grows. Dare I say, with my own jurisdiction, as one of the fallouts from Brexit, there may be more, and indeed one of the BITs is with the UK, there may be more, I'm sure there's more trade to be done, and we are crying out to do work, trade with other countries from the UK perspective. But beyond that, there are many other within the region and further afield. So I see this as there are relatively few competitors in the region, but I think there are natural reasons why, in some ways, Uzbekistan is certainly ahead of the game and would be perhaps a natural first choice. So it's definitely a very optimistic picture, but one that has to be followed cautiously, pragmatically, following the strategy that has already been outlined and developed. So I think with that, I just wanted to add that.
Look, and frankly, who wouldn't want to visit Tashkent and Samarkand?
Exactly. Especially as you can go on a Spanish train between the two.
Thank you very much for all your insights. I'm very thankful to all of you, Joe and Arif. And of course, as you said, there are many reasons to visit Uzbekistan, and arbitration is definitely not the only reason why. There are many beautiful places as Samarkand and other cities. But at this point, I would like to pass the list to Charles. I see that there are no more questions on the chat box. And also, I would like to point that Diana put on the chat box some GAR article on TIAC and other related materials on GAR and other CAF news on development of TIAC and the adoption of uncitral model law. For all intellectual curious, they will find useful information there. And with that, Charles, I would like to pass the list to you.
Well, yeah, so it's we have the final 10 minutes left for this session. We wondered if there would be anybody from the audience who would like to interact with the court or board members, and if so, you're free to unmute yourself, speak up, ask them directly. If
well,
not,
I was going to say everybody except Elijah. Unfortunately, I think his router seems to have fried as well.
Yes, now it's a trendy issue, the fried router.
I have a question on my end. Earlier on, I think Arif talked about there was a mention about competition, and so like I wondered, in the course of the past several years, we have seen that there are several international commercial courts that have been that have been set up or launched across the world and even in the region. And some examples are in the neighboring country of Kazakhstan, the Astana International Financial Center courts, And over in China, there's also the China International Commercial Court. Would any of you have any thoughts about the interaction or intersections between these courts and the work of TIAC?
I could start, probably. So competition is always good because it contributes to the quality of the services of all this institution involved in the competition exercise. So it's not something new, because I think this is normal development both on regional, local, and international level. And many jurisdictions have realized that they want to develop institution arbitration in their jurisdiction and promote the existing institution, or make some other steps in order to promote arbitration and promote itself as a place of arbitration. So this is normal and very good positive development, because this would end up in the end of the day in greater number of arbitration cases, and for arbitration practitioners, I think this is a good news. With regard to TIAC, again, I think so TIAC was launched before COVID appeared, and it was quite interesting that from the very beginning TIAC use technologies to the greatest extent. One of my first questions as a court member was whether I need to come to Uzbekistan to perform my function as a court member, because at that time, again, if we compare with ICC, in order to take part in ICC plenary session, it was necessary to come to Paris physically, or to any other office of ICC. With TIAC, the starting point that everything should be remotely to the greatest extent. And I think this was one of the very, very good ideas, because other institutions in the region during the COVID only started to implement some of the practices and technologies which TIAC used before, and I think for TIAC it was a competitive advantage. So to say, in terms of promoting itself on the market, so again, the user will choose in the end of the day, and the choice would be driven by many factors. And in this competitive situation, it's necessary to first to provide high quality services, to be visible, and to again to promote the institution among the users, and also to react on any feedback received from the users. I think it's also important. But in any, I think this is nothing. So it for the development of institution.
Yeah, I'll just springboard off that, Olena, because I think that we could of course discuss for hours why it is that these international commercial courts have gained traction as quickly as they have, and why more and more countries are thinking about them. I think that it's obviously it's a good thing for international investment and commerce, but ultimately I think that we also have to look at why it is that parties, legislators, trade associations have been so much in favor of these international commercial courts. It's because in the world of arbitration, we have, I think, done a disservice to the users, and I think this is a real opportunity for an institution like TIAC that is so focused on innovation to stay ahead of the game and perhaps take arbitration back to its roots, where we need to, arbitration has become sort of more arbitigation, and I think it's a responsibility for the institutions, for academics, but most importantly for counsel, to understand that arbitration was always intended to be something different, and that it is a service, it is a tool. It has to be a tool that is used efficiently, or it's one that's going to be the source of its own demise if we don't recognize that these competitive forces need to take us back to arbitration's true roots of efficiency and cost savings. So,
thanks very much, Olina. And
TIAC is doing a lot in that area.
Very fascinating. Just to end off on the forward-looking note, I'd just like to ask a very short question and I'd like very short answers on this from the panelists. What are some of your visions on how TIAC may develop to be like in 5 years' time?
More cases.
More cases. Dirk, any ideas?
Well, I think it will be interesting to see whether the technology rules are adopted and people start accepting those and using those. I mean, the other thing that one needs to bear in mind, of course, there is an evolution period. I mean, in your 5 years, you've got to get them into the clause into the contract, and it takes a while before the dispute actually will arise in any event. So, but I think, yes, I think one would hope to see a bigger caseload and a wider recognition that this is truly an international arbitration center that we've been discussing. And if I may, just on that, time is, the proof of the pudding is time. I mean, at the minute, all these wonderful initiatives like the new law, the fact that the courts seem to be arbitration friendly is great, but that can change. Arif alluded to that earlier on. And I think if people can see, the longer that this goes on, that this is a safe, arbitration friendly jurisdiction that has real cost advantages and other competitive advantages, then the more credible and more natural it would be. Everybody took time to set up. That's why I could repeat these things, one has to be realistic and take a long-term view, but there is actually no reason. It's a huge region, relatively little competition in the region. You look at Europe, we're saturated with institutions, and there's more than enough work for all of them.
Thanks very much, Joe. I asked Dirk for an answer earlier on, but it seems that he's having a technical issue, and so he's not able to share his thoughts. That's such a pity because I really wanted to hear them. But well, anyway, so now we have moved to the end of our webinar. We can see that we have 1 minute left. I would like to take this opportunity to thank all of our great speakers who have taken time off their busy schedules to share their thoughts and wisdom over here with all of us. And Orlando and I, between us, we would like to use this opportunity again to share with the audience about Uzbek Arbitration Week. And this year, the Uzbek Arbitration Week will be held in a hybrid fashion due to the ongoing travel restrictions. But perhaps because of this, we think that this is a great opportunity for everyone in the audience to join from all parts of the world to learn more about arbitration in Uzbekistan and the TIAC. The Uzbek Arbitration Week will be held from 6th to 10th September, and its website is uzbekarbitrationweek.com. If you are able to attend, all of you are cordially invited to do so. And for those of you who may have the opportunity to travel to Uzbekistan, we hope you can have the chance to enjoy the capital, Tashkent, Samarkand, the Spanish train, and the many other wonders that the country has to offer. And for those who can't this year, we hope that you will have the chance to sometime in the future. And with that, I would like to say again, thank you to all of our 5 distinguished panelists over here who have came to speak with us. It has been a great pleasure. And Orlando and I look forward to having the chance to meet all of you in person when things in the world permit that. So yes, thank you everybody, and bye-bye.
Thank you both.
Thank you. Bye-bye.
Bye-bye.
Thank you.